In a shocking courtroom moment, a man accused of several violent crimes appears before a judge for a bond hearing that quickly spirals out of control. The defendant is facing 7 serious charges, including attempted murder, torture, and criminal sexual conduct, allegations so severe that they could lead to life in prison if he is convicted. From the very beginning of the hearing, tension fills the courtroom as the judge and officers attempt to explain the disturbing details of the case. According to investigators, the accusations involve a series of brutal acts that allegedly took place over several days. Authorities claim the victim was assaulted, held underwater until she nearly lost consciousness, and forced into sexual acts. The case only came to light after the victim managed to contact someone and ask them to call 911. As the officer explains these allegations in court, the seriousness of the situation becomes clear. However, instead of remaining calm, the defendant repeatedly interrupts the proceedings. He denies the accusations and argues loudly while the officer is speaking, despite warnings from both the judge and his own attorney to stay quiet. His emotional outbursts and confrontational attitude quickly draw the judge's attention. Meanwhile, the defense attorney argues that the accusations are still only allegations and asks the court to set a lower bond. She explains that the defendant disputes the claims and says he has ties to the community, including family members he could stay with if released. But prosecutors and officers strongly disagree, warning the court that the charges are extremely serious and that the defendant could pose a danger to both the victim and the public. As the defendant continues interrupting the court, the judge grows increasingly frustrated. What started as a standard bond discussion suddenly turns into a lesson about courtroom behavior. Because of the defendant's impulsive and disrespectful actions, the judge decides to raise the bond dramatically, sending a clear message that losing control in court can have serious consequences. By the end of the hearing, the situation has escalated far beyond what anyone expected. The judge's final decision leaves the courtroom stunned and highlights just how quickly things can change when emotions take over during a high-stakes criminal case.
Versus Danny Eugene McDowell, charged with count 1, assault with attempted murder, count 2, torture, count 3, criminal sexual conduct, first degree, felony, count 4, unlawful imprisonment, count 5, criminal sexual conduct, third degree force or coercion, count 6, assault with intent to great bodily harm less than murder or by strangulation, count 7, domestic violence. Officer, state your name for the record.
Detective Christopher Wilder, Plymouth Township Police Department. Plymouth Township Police Department responded to 12811 Heritage Drive, apartment 203 on 7/13 at 3:58 in the afternoon for a welfare check on a victim. You can take a step back, sir. Good. Once they arrived, they contacted the defendant who's in custody, Danny McDowell, and the victim, Faith Allen, at the residence. After speaking with both of them for some time, they were separated. Assault was determined that it happened. McDowell was placed under arrest for domestic. He was transported back to the station. I, as the detective on call, was sent out to the scene, conducted field investigation, conducted interviews. Was found to believe that on Tuesday, a couple of days prior, so it would have been 7/11, assault occurred, including 3 different times where the suspect placed the victim underwater, held her underwater, and at one point on the 3rd assault actually drowned her to the point that she lost consciousness. Once she woke back up, she went to the bedroom.
All this occurred on the same day?
This was over 3 days, Your Honor.
Over a 3-day period?
Yes, Your Honor.
Okay, go ahead.
So on 7/11, that's when the actual 3 drownings occurred. Third one, she passed out, was no longer conscious. When she woke up, she went back to the bedroom. The defendant forced her to perform oral sex on her at that time, or on him at that time. The assault stopped at that point. After he fell asleep the next morning, he slapped her a couple times, which would have been on the 12th. Nothing else occurred on the 12th. We approached to the 13th. The 2 of them had consensual sex at that point on the 13th, after which he threatened to have her fill up the bathtub a second time, to which she was able to reach out to a colleague to call 911 and that's how the police department got involved in the matter.
Okay, what was the torture involved? Was that the strangulation or whatever?
I believe, Your Honor, that's what the prosecutor's office determined to be torture.
Okay. All right. It looks like mental pain or suffering or whatever. All this occurred in the Plymouth, Michigan?
Yes, sir. Plymouth Township.
Plymouth Township. Okay, stand corrected.
Crystal Marie Medina, Your Honor, on behalf of Mr. McDowell, with regard to the arraignment, we would waive formal reading and stand mute, Your Honor.
Yes.
Okay, Mr. McDowell, state your name for the record.
Danny McDowell, Danny Eugene McDowell.
Okay, thank you. Mr. McDowell, your attorney having waived the formal reading of the complaint and warrant, the court will enter a not guilty plea in this matter. Argument as to bond, please.
Your Honor, at this time, so we did have the opportunity to speak with Mr. McDowell. I do understand that these are very serious allegations, Your Honor. However, I would ask the court to consider that at this time, they are just that, allegations. Mr. McDowell disputes these allegations, Your Honor. He looked forward to coming to court and addressing the allegations that have been made against him. Mr. McDowell indicates that he is able to stay with his mother at his mother's home on Deacon Street in Detroit, Michigan. He indicates that he understands he's to have no contact with the complainant or with her address, Your Honor. He is 36 years old. He is not currently on probation or parole. While we do see that he has a criminal history, a felony, a previous felony conviction, it was back in 2006, Your Honor, and that was for an unarmed robbery, Your Honor. He indicates that he drives for Uber. His monthly income varies, but given his variable monthly income and his expenses, he is not able to post a monetary bond at this time, Your Honor. And so I would ask that the court, he also receives food stamps, Judge, so that means he is under the guidelines. And we would ask that the court consider giving him an opportunity to come to court and address these allegations, Judge. He is a lifelong resident of Michigan, if I didn't mention that already.
All right, thank you. Officer, you have any comments or thoughts as to bond?
Yes, Your Honor, due to the serious nature of these crimes and the fact that we believe that he's a safety risk to the public, we're asking for a high cash bond, at least $250,000, if not higher. If you do decide to release him, I'd at least ask that he be on a GPS tether, have no contact with the victim, not be allowed to live at the victim's house, not be on any kind of alcohol, drugs, anything like that. So to be testing for that kind of thing and then be in contact with either probation or somebody so that we can kind of monitor what's going on with him. But again, just due to the seriousness of the crimes and our fear for the victim's safety at this point, if he does get released. He did mention during when we were having him process that don't worry, none of the victims are going to come here to testify. So again, we're worried about the safety.
Come on, man. You don't lie like that, man.
Okay.
You don't have no evidence, man. You just taking her word for it. He just taking her word for it. He don't have no evidence, Your Honor. And I did not say that. I said they're not going to come because it's not true.
Mr. McDowell, you have the right to remain silent. I would strongly suggest you exercise your right.
Response from my client, right? Again, Your Honor, that comment, if made, could have been made for several reasons. One can take it as a negative way, or it could be taken as they lied from the beginning, and so they're not going to come to court and lie under oath, Your Honor.
Exactly.
So I would ask that
Mr. McDowell.
I'm sorry, sir. I'm sorry, sir. This emotional moment.
Mr. Medina, hold on one second.
I'm
Mr.
sorry,
McDowell.
sir. I'm just emotional right now, man.
It's one thing.
I'm sorry. I'm just emotional.
Are you going to be quiet? Go ahead. Mr. McDowell.
Yes, sir.
You not only interrupted the court, you interrupted your attorney. And he said she's trying to help you.
I know, sir. It's just, I'm sorry.
Okay. Now, I want you to step aside and be quiet for the remainder of this hearing, okay?
Yes, sir.
Thank you.
Thank you, Your Honor. And so I do think, again, if that comment was made, it could have been made for various reasons, Your Honor. And so I would ask that the court consider that these are verbal allegations that are being made at this time, and that my client has lifelong ties here, and that his previous conviction was back in 2006, Your Honor, and that somehow after 3 days, there was access to there's a lot to be flushed through here in the facts, Your Honor, okay? And so I would ask that my client be given the opportunity to come to court and do just that. He understands he's having no contact with the complainant, and I would ask that the court consider all of that, Your Honor.
All right, thank you, Ms. Medina.
Thank you.
The court, having heard representations of the attorney and the officer on this matter, what is very, very troubling and is indicative that Mr. McDowell cannot control his emotions and impulsive were just demonstrated. And he admitted he's very, very emotional. He responded disrespectfully not only to me, to the court, but to his attorney, and who's acting in his best interest. And so, given his demonstrated impulsiveness, the court's going to adopt the recommendation of the officer, a $250,000 cash surety bond, no 10%. If he's able to post that bond, no contact with Faith Allen, and no contact with the Heritage Drive apartment located in Plymouth, Michigan. Your probable cause conference date is July 27th, 9 a.m. at 35th District Court. The preliminary examination date is August 3rd, 9 a.m. Just to be clear, and just to clarify the court's ruling, the court deems Mr. McDowell a safety to the community, a safety to the community witness in this matter, and given his extended emotional outburst before the court just now, the court
if he trying to give me life, why wouldn't I be? He trying to give me life. He don't have no evidence, sir. Why wouldn't I be? He trying to give me life. Man, shut up talking to me because you trying to give me life, man. And you know it's not true. And he know it's not true. Why wouldn't I be emotional? He trying to give me life. He ain't got no evidence on none of this. And he's asking for a $250,000 bond. What's wrong with him, man? He don't even got no evidence. Who touched me, man? You ain't got no evidence. Of course I'm be emotional, man.
Sorry, Your Honor.
He just got me a $250,000 bond with no evidence. Yeah, I'm emotional.
Okay, the court's going to change the bond to $500,000.
Wow, sir, you can change to $500,000. He's still lying. He don't have no evidence. Now it's $500,000. Make it $1 million. It don't matter. I can't post 250,000.
Okay, I'll make it $1 million then.
I can't post none of it anyway.
Okay, sir, step aside. This concludes the hearing.
Okay, Your Honor, so the final amount for the bond?
$1 million.
And is that
cash surety?
He's seen all that shit on her wall, and he ain't taking none of that evidence down, man. I know what he's trying to do, man.
Your Honor, he was put back in a cell. I'm sorry about that, Your Honor.
Okay, no problem. That concludes the hearing. Thank you, officer. Okay.
The courtroom is quiet as a man accused of extremely serious crimes stands before the judge. Everyone in the room understands that this is not an ordinary case. The charges against the defendant are severe, and if proven in court, they could lead to life in prison. The defendant, Danny Eugene McDowell, has been brought into court for a bond hearing. This hearing will determine whether he can be released from jail while waiting for trial or whether he must remain behind bars. From the moment the hearing begins, the tension in the room is noticeable. The judge sits calmly at the bench, reviewing the case, while attorneys on both sides prepare to present their arguments. But even before the full details of the case are explained, the defendant's behavior begins drawing attention. Instead of quietly observing the proceedings, he appears restless and emotional. His reactions suggest frustration, and it becomes clear that controlling his emotions may be difficult during the hearing. The judge signals for the case to begin. A detective from the local police department steps forward to explain the accusations that led to the arrest. As the officer begins speaking, the courtroom grows silent. The allegations described are disturbing. According to investigators, the case involves a series of violent acts that allegedly took place over several days. Prosecutors claim the victim endured repeated assaults during that time, creating a situation that authorities describe as extremely dangerous. The detective explains that the investigation began after an emergency call was made to authorities. The victim had reportedly managed to contact someone she trusted, asking them to call 911. That phone call would eventually lead police officers to uncover the situation and begin gathering evidence. As investigators looked into the allegations, they began piecing together what they believe happened during those days. According to the detective's testimony, the victim claims she was assaulted multiple times and placed in situations where she feared for her life. One allegation stands out more than the others. Investigators claim the victim was forced underwater until she lost consciousness. Authorities say this act is one of the reasons the defendant is facing a charge of attempted murder. The courtroom remains completely silent as these details are described. These are not minor accusations. They represent allegations of prolonged violence and control. While the officer continues explaining the case, the defendant begins reacting again. He shakes his head, speaks under his breath, and eventually interrupts the testimony. His attorney immediately leans toward him, quietly urging him to remain silent. Courtrooms operate under strict rules, and interrupting proceedings rarely helps a defendant's situation. But emotions appear to be running high. The judge looks toward the defendant and gives him a clear warning. The court will not tolerate disruptions, and he must remain silent while the officer speaks. For a moment, the room settles again. The detective continues explaining the seriousness of the charges. The case includes multiple accusations, including attempted murder, torture, and criminal sexual conduct. Each of these charges carries extremely severe penalties. The prosecution argues that the nature of these allegations shows a pattern of violence that could place the community at risk if the defendant were released. As the officer finishes explaining the investigation, the defense attorney stands to respond. Her role is to argue for her client and ensure the court considers every factor before making a decision. She begins by reminding the court of an important principle in the justice system. At this stage, these accusations are still allegations. The defendant has not yet been convicted, and the purpose of a bond hearing is simply to determine whether he should remain in custody until trial. The defense attorney explains that her client disputes the accusations. She also emphasizes that he has ties to the community. According to her argument, he has lived in the state for most of his life and has family members who could provide a stable place for him to stay if released. She mentions that he could live with his mother while awaiting trial, suggesting that this would provide supervision and stability. The defense also acknowledges that the defendant does have a criminal record, including a felony conviction from years earlier. However, the attorney argues that this past conviction should not automatically determine the outcome of the current hearing. Another major point she raises is financial ability. Bond amounts must be reasonable, she argues, and the court should consider what the defendant is realistically capable of paying. Setting an extremely high bond would effectively guarantee that he remains in jail before even having the chance to defend himself in court. Once the defense finishes speaking, the prosecution responds. The officer representing the investigation stands again and explains why authorities believe a high bond is necessary. He emphasizes the seriousness of the charges and the potential danger to the victim. According to investigators, the victim could still be at risk if the defendant were released. The officer also mentions something that raises additional concern. Investigators claim the defendant previously made statements suggesting that victims would not testify against him. To the prosecution, this raises fears about possible intimidation or interference with witnesses. Because of these concerns, the officer recommends a very high cash bond. He argues that anything less would fail to protect the victim and the public. While these arguments are being presented, the defendant once again becomes visibly upset. He interrupts the officer, insisting that the claims are not true. His voice grows louder, and the judge immediately looks in his direction. The judge warns him again that he must remain silent. Courtroom hearings follow strict procedures, and emotional reactions can quickly make a situation worse. Despite the warning, the defendant continues reacting to the statements being made. His attorney once again tries to calm him down, whispering that the best thing he can do is remain quiet. But the damage may already be done. Judges carefully observe the behavior of defendants during hearings. These moments can influence how the court views a person's ability to follow rules and remain calm. After listening to both sides, the judge prepares to make a decision about bond. The courtroom grows quiet as everyone waits. The judge explains that several factors must be considered: the seriousness of the charges, the defendant's criminal history, the safety of the community, and the risk that the defendant might interfere with witnesses. Based on these factors, the judge announces the first decision. The bond will be set at $250,000 cash surety. For a moment, the courtroom remains silent, but almost immediately the defendant reacts again. He begins speaking loudly, challenging the statements that were made during the hearing. The judge watches carefully. Interrupting the court after a ruling has been made rarely ends well. As the defendant continues arguing, the judge becomes visibly frustrated. The judge explains that the defendant's behavior demonstrates impulsiveness and a lack of control. That behavior, the judge says, raises concerns about how the defendant might act if released. Because of this continued disruption, the judge makes another decision. The bond is increased even higher. The room becomes quiet again as the new amount is announced, but the defendant continues speaking. At this point, the judge makes it clear that the courtroom will not be turned into an argument. When the defendant challenges the court again, the judge responds decisively. The bond is raised once more, this time to $1 million. The message is unmistakable. The judge explains that respect and self-control inside a courtroom are essential. The defendant's repeated outbursts have only reinforced the court's concerns about public safety and impulsive behavior. By the time the hearing ends, what started as a routine bond discussion has turned into a dramatic courtroom moment. The judge concludes by explaining that the decision is based not only on the seriousness of the allegations, but also on the behavior shown during the hearing. For now, the defendant will remain in custody while the case moves forward through the legal system. And the courtroom is left with a powerful reminder that in the justice system, every action matters. Sometimes the way a person behaves in just a few minutes can influence a decision that changes everything.